Hello and welcome to Third Thursday with GBLA. Thank you for joining us today. Today's presentation, we're going to go over some basic definitions of what our housing unit does, our Housing Navigators, and then we're going to go over a brief process on the resources we provide to individuals that are seeking rental utility assistance. It is Thursday at 4 p.m. We're going to go and get started in just a moment, so just hang tight. Okay, thank you for being patient. I had a few individuals to let in. So we're going to go ahead and get started. My name is Cassie Mulliken, and I am the Marketing and Communications Coordinator with Greater Bakersfield Legal Assistance. As I mentioned a moment ago, we're going to go over a presentation on housing services we provide here at GBLA. I do want to start off with a disclaimer, just informing you that information here is not intended to, nor does it constitute as legal advice. I am not an attorney and am not providing any information that can legally be able to be used in any case. Some of the information that might be in this presentation might be expired. At this time, none of the information is, but just so that you're aware, things do change. Policy does change on a regular basis. So as of right now, the information we're providing to you today is relevant and is current. But again, this does not constitute as legal advice. This also does not create an attorney-client relationship of any kind, and any actions the individuals take based on the information provided here and is expressly disclaimed. So we're providing you information as is and no representation that is error-free. So a little bit about what our housing navigators do here at GBLA. So we have a set team of individuals called housing navigators that help individuals through different processes. So we provide support and general information in regards to landlord-tenant issues. We're going to go a little bit more into depth about different types of notices that tenants tend to receive and how to reply to those notices. We advocate for individuals. So whenever we receive a client and we take a case regarding any type of matter, we always provide a well-rounded supportive service approach. And what that means is not only do we help them with their issue at hand, but we may also bring referral services to either other programs or units within our organization or to outside resources. Another big one that we help with right now is assistance with the rental assistance applications as well as utility assistance applications. I'm going to go a little bit into depth about what the current rental assistance application process is with the Housing Authority of the County of Kern and what we do to help provide, and then go over some information about denials. We also help individuals with budgeting issues. So when we have tenants that come in that tend to have issues with finances and regarding how they're able to pay their rent, food, utilities, and then support their children if they have children as well, we do provide assistance to them and help them budget in a way that is beneficial for them and their families. We do a lot of community linkages, meaning we help individuals apply for public assistance programs, make referrals to outside agencies. 211, we do a lot of referrals to 211 for our homeless individuals that are seeking assistance with navigating housing resources. And then of course we also provide a housing search in that matter as well too. So if we have an individual that is homeless or at risk of homelessness, we will provide assistance with helping them locate available rentals in the county of Kern. As of August 31st, the Housing Authority at the County of Kern, commonly known as HAC, will the deadline to apply for the rental assistance program, which is the emergency relief monies that were given to individuals that were financially impacted by COVID. That deadline is going to be August 31st. This is important if you have individuals that you work with on a regular basis, so they understand that those applications must be submitted. Now, with that, they did do a report a couple months ago and reported back in June that as of July 1st, they would stop, they would only process high priority cases, high priority applications. So the highest priority group are those that make less than 50% of the median income level and are either homeless or at risk of homelessness. And then the other individuals are those that are underneath the 200% threshold, but over 50%. So applications that have been submitted prior to that date, it is our understanding those applications are still being processed, but right now there is a hold and only the highest priority applications are being processed first, and then they'll run through until monies are expended. So it's important that individuals understand that in order to apply for this emergency rental assistance, they have to apply through the HAC portal. And then when they apply for this information, you have to make sure that you would check that account regularly. So unfortunately, when it comes to like denials of the application, the portal does not tell you why the application was denied, but it does notify you that it was. Now, we are aware that some of these applications have been submitted and have taken time to go through to process. So we'll go over a little bit of information about what that means for tenants who either have not had their application processed or might have received a denial notice. And then also make sure that if you are an individual that applied for rental assistance, or if you have clients that you've helped refer to apply for the assistance, they understand that they must keep an eye on their email or regular physical mail for contact letters. So these letters typically will inform you that the caseworker at the housing authority has been trying to reach them and that it's been unsuccessful. And it's very important that the individuals keep an eye on that stuff because there might be information that caseworker needs and they need to respond by that particular deadline on that letter. So, and not responding to those letters can then cause your case to be denied. One thing that we have noticed is information has changed for some of our clients. So if a phone number, for example, is changed, you have to go back into that portal and update your information on a regular basis. So if you have an application or your client currently has an application for the rental assistance program and any of their information has changed, whether that be their email address, their phone number, their physical address, make sure they notify their caseworker over at Housing Authority as soon as possible so that they can be sure that they are notified in prompt time. So with the rental assistance deadline coming up, one other thing that we have noticed here commonly that most people really don't understand the process of is the denial of the rental assistance program. So their rental and utility assistance award and denial letters are physically mailed, and the date of the letter is the beginning of what's called the appeal filing deadline. So if you have an application or your client has an application submitted and they receive a denial notice, there is a 10-day denial time frame with which they have to appeal that case. So if they have a physical copy that came in the mail, they're going to want to respond and appeal that process as soon as possible because the time that it takes to mail that letter does also take in consideration that 10 days. So it's very important that if you receive a denial notice or your client receives a denial notice, they contact their caseworker at Housing Authority immediately so that the reason for the denial can be identified, and then they can request an additional letter stating the reason. And then again, that does get provided either by physical mail or email. Now, there are a lot of reasons why an application can be denied. It could be missing information. Maybe they didn't submit income verification on time. Maybe the caseworker was trying to contact them for a certain period of time and they were unable to be contacted. That could cause a denial. One thing that we noticed here at GBLA with these denials is some of the information has been exactly that, missing information. So they have tried to contact the particular client, and now the Housing Authority does a really great job of trying to make those contacts as much as possible, again, either by physical mail or by email. So there will be so many attempts that they will try to reach out to an individual, and you have to respond to that in a certain period of time. So some of the cases that we have seen where denials have happened is maybe they applied for the assistance back in February, and their income verification may have been expired by the time the application was actually processed, in which case a worker would have requested an updated income verification form. Numbers could have changed, physical addresses could have changed. There's a whole reason why these denials can happen, but it's important that people understand that you can appeal those denials, and we have had success in doing that here at GBLA. So now the appeal itself can be done either physically in writing or electronically by visiting the Housing Authority portal, and they will type in the appeal box and select the appeal button in the application portal. So again, if a tenant has received a denial letter, they need to contact their Housing Authority caseworker as soon as possible to figure out what the denial was for, so they can either appeal the process or provide the proper documentation to process the application. Once the appeal is actually submitted, the application will be assigned to a case auditor who will request additional documents. Again, it's very important that tenants pay attention to their email that they provided when they applied for the rental assistance program and their physical mail, because there are time frames. So, and then the information that is requested by the caseworker or the case auditor needs to be done immediately. So as soon as possible, as soon as you receive that letter, call the worker, provide the documentation they are receiving. So at GBLA, we have been helping assist individuals apply for the rental assistance program from the beginning. Now with that, all we have done is guide them through the process, help them with the portals and collect their information. We have been very successful in helping individuals make sure that they contact a caseworker on a timely basis. Another thing that we have noticed is there has been some denials that have occurred, and we actually do provide assistance to individuals that receive those denials. Now, I mentioned earlier that the Housing Authority announced that rental assistance program deadline to apply is August 31st. But we do anticipate that the processing of those applications will continue for a continued period of time. There's no time frame that we have that we can provide to you, nor can the Housing Authority do so at this time. Essentially, they are processing applications and providing rental assistance to individuals as money allows. So once that allotted money that they have for that program is expired, there's nothing more that they can do. Their hands are tied. So it's very important that tenants understand that they reply to that denial process as soon as possible and appeal within 10 days. And if an individual has received a denial and aren't quite sure how to proceed forward or need additional assistance, our housing navigators are on hand to provide that assistance. So please have your clients, or if you are an applicant of the rental assistance program, to call us immediately at 661-325-5943. Make sure you state to the intake line that you are calling in regards to the rental assistance program and the denial, and we will make sure to get you hooked up to a housing navigator. So with that, we're going to go a little bit more now into types of tenancies and different notices that tenants typically receive from landlords. So there are some key differences when it comes to the types of tenancies that individuals have. So the first type of tenancy is what's called a fix. So it's a tenancy that typically happens for a period of time. You do have to have landlord consent to have a fixed tenancy. The term is either a definite term other than for life. So individuals will have, it won't be a year lease to lease option. It'll be something that'll be like it'll be a definite lease agreement between the landlord and the tenant. Rent is paid on a regular basis, and then automatically upon the term's expiration, the landlord must still serve a termination notice if TPA applies. And TPA is the Tenant Protection Act of 2019, which we'll go a bit more into depth in just a moment. The next common type of tenancy is a periodic tenancy. So again, this requires landlord consent, and these are more of an indefinite successive period of time. So it might be a week to week, a month to month, or a year to year. The most common types of leases that we see in these types of situations are either a month to month, but more common is a year to year lease. So there is, individuals do provide rent, and payments are paid during a successive period of time. And then termination for that type of lease can be made by either party, but notice must be provided, and the landlord must still serve a termination notice if the Tenant Protection Act of 2019 applies. The third type of tenancy is an at-will type of tenancy. Again, this is a landlord consent. There is no particular term for this one, so this is the more of the type of notices, the type of tenancies we receive, like maybe a room for rent, staying with a relative or a friend or so forth. Typically, rent is paid, but it's not necessary. It might be a relationship between two individuals. There might be a different type of agreement. And again, in termination of that type of tenancy can be done by either party after 30 days. But again, the landlord must still provide a termination notice if the Tenant Protection Act of 2019 applies. So I've mentioned the Tenant Protection Act a couple times. And so what exactly that is the Tenant Protection Act of 2019 prevents a residential real property owner from terminating a tenancy if the tenant has continuously and lawfully occupied a residential property for more than 12 months and there's been no stated just cause and written notice to terminate. So whenever you are in a lease, so whether you're in a fixed periodic or tenancy at will, typically you will already have a lease with a fixed or periodic, but particularly with the tenancy at will, make sure you always request a written lease. The written lease will always be your backup and support system to help avoid future disagreements with your landlord. Too often we see individuals that have been allowed to stay with an individual for a period of time, and then all of a sudden the individual that owns the home or lives in the home is like, you've got to go, and there's nothing in writing to state what those requirements are. So legally, you do still have to provide a notice of termination to an individual if you are going to terminate a tenancy. But for a tenant, for their own protection, please make sure they always have a written lease, something in writing that states what exactly those boundaries are and what should occur in the future on termination if the tenant is not complying. So I'm going to go a little bit more into the types of terminations. It's a very common misconception that individuals receive a notice from their landlord and they assume it's an eviction. It's important to note that a pre-eviction termination notice is not an eviction. It is a notice to comply or vacate the property before the eviction process begins. So typically what we will see is notices like a 3-day pay or quit. So if you don't pay your rent on time, the landlord might issue a 3-day pay or quit notice. And what that means is you have 3 days to either pay the rent or go ahead and prepare for termination of residency. That does not mean the individual is actually being evicted. That 3-day notice is then followed by a 30-day notice in most situations. I'm going to go a little bit more into different types of 60-day and 90-day notices for certain types of properties in a moment. But typically, you'll receive the 3-day notice first, and then the individual will receive a 30-day notice. Now, that 30-day notice is informing them that their lease is going to be terminated. They are being asked by the landlord to vacate the property, and they have 30 days to do so. So if a tenant does not comply with that notice and they are not out within that 30-day time frame, then the landlord can begin the eviction process in court once that time period has expired. This is important to understand because the eviction is what actually goes on to individuals' records, not necessarily a 30-day notice to vacate. So a termination notice is that forms the basis of an eviction must also be attached to the complaint. So whenever a landlord files that eviction process, they're going to have to attach all documentation they provided to the tenant in regards to requesting the termination of tenancy. So that would include the 3-day notice of pay or quit, and then it would include the 30-day notice that says the individual did not comply with a 3-day pay or quit notice, and therefore we're going to go ahead and terminate the tenancy at this time. So all of that information has to be attached to that document, to that eviction process. Now there are several different types of termination notices that do exist, and the type of termination notice determines how the tenant may avoid the potential eviction, which we're going to go into in just a moment. So the different types of notices for termination are as follows. There's either an expiration of a fixed term lease. So we mentioned earlier there were different types of fixed term leases, whether that be week to week, month to month, or year to year. Once that time period has expired, the landlord has all reason to ask an individual to leave the property without just cause. So the lease has been expired, and there's a variety of reasons why this could be done, but typically landlords will ask individuals to leave if they're going to be selling the property. Maybe they want to move back into the property themselves or family or for whatever reason, but that is not illegal. Once that lease has expired, it is not illegal for that landlord to request that the tenant vacate the premise. The most common that we see is a failure to pay rent. So a lot of times individuals will receive, again, that 3-day notice to pay or quit. Once that 3-day pay or notice is expired, they will go and they do not either contact the landlord to make arrangements or they pay their rent. That's when they'll receive their notice to vacate, and it'll either be a 30, 60, or 90-day notice. And this is something that we have seen really common the last 2 years. Individuals automatically assume that when the COVID restrictions were put into place and the eviction moratorium was rolled out through California, the big misconception was, well, I'm financially impacted, so I don't have to pay rent. That was 100% false. That is not how that policy was written, nor was it supposed to be construed in that manner. The moratorium was in place to protect individuals that were financially impacted due to COVID-related illness. And so individuals might have either had a reduction in hours at work, lost their jobs, had some kind of situation where their income was severely impacted. And so what that moratorium did is it prevented landlords from evicting tenants based on failure to pay rent, because there were certain things that were put into place to help those individuals. And this is where the programs like the emergency rental assistance program came in through the Housing Authority. This is exactly what these type of programs were put into place for, was to help individuals that were financially impacted by COVID to ensure they were able to continue to pay their bills. So that failure to pay rent is something that we have seen very commonly in the last 2 years. And unfortunately, because of programs like the Housing Authority Rental Assistance Program and CAP-K's Rental Assistance Program, a lot of individuals have been able to stay in their homes. And so we're very grateful for those opportunities. And working with those agencies has been an amazing experience for us, because the more people we can help stay housed, the better for our community. The next common termination notice that we see a lot of is the breach of lease agreement. So most individuals, and I mentioned a little bit earlier that there might have been more of an at-will type of tenancy. They may not necessarily have a written lease, but this is why we encourage individuals to have a lease in writing. So typically, landlords or property management companies will have lease agreements in place, and there'll be a certain set of rules. The tenant, when they sign that lease, they are saying that they agree to these particular types of rules. Now, different properties have different types of agreements. Not everything, so what might work for one individual may not necessarily work for the other individual, but that lease agreement, that breach of that lease agreement is a just cause to terminate tenancy. The most common that we see in terms of breach of lease agreement are typically to do with situations where it creates a nuisance on the property. So there might be just for example, it's not necessarily a case that we've handled, but for example, there might be a noise policy. You might live in a gated community, and there might be a noise policy in effect that says, you can't have excessive noise after 10 p.m. And then maybe there's a group of individuals that are having excessive noise till 3 a.m. every single night of the week. That could constitute as a breach of lease agreement, because they signed on that form that they agreed to those agreements of the landlord. So I just mentioned the nuisance issue, but then there's the committing of waste. So creating excessive amount of waste on the property, or creating a situation that is uninhabitable for either the resident or other residences near them. So whenever the Tenant Protection Act does not apply, you will typically see what's called a no reason for termination notice, and these are 30, 60, or 90-day notices. So unless if there is a lease in place that's either month to month, month to month not necessarily go through, but a year-to-year lease. So if a tenant has a year-to-year lease, and the Tenant Protection Act of 2019 does not apply, they can receive a no reason for termination in the form of 30, 60, or 90 days. But typically it has to be outside of that first year lease, and then those notices can be issued anytime after. The next type is a 60-day notice, and this is more of a just cause reason, and it must be stated whenever the Tenant Protection Act of 2019 applies. So the 60-day notice is typically we see a lot of those types of cases when individuals, property owners, are wanting to take back the property for their own reasons. Maybe they want to sell or so forth. So they will typically give a 60-day notice to individuals, so there's ample amount of time for that individual to relocate. And then you have your final, which is the 90-day notice. This is pretty common for individuals. They are going, so the property owner themselves loses the home to foreclosure. This is when you'll typically see a 90-day notice. So the resident will be notified that they have 90 days to move out before the bank is taking over. Once the bank takes over, eviction process can move forth immediately. So then there are what's called pay or cure notices, and I mentioned a little bit about this previously. So the most common that we see is a 3-day notice to pay or quit. So a pay or quit notice, again, usually is given by the landlord to the tenant if they are outside their outside the time frame of when the rent is due. So a 3-day notice, so let's say that the rent is due on the 5th of the month. On the 6th, the landlord may issue a 3-day notice to pay or quit. Now that 3-day notice does exclude judicial holidays and weekends. So let's say that the 5th is on a Thursday and the tenant receives the notice on Friday the 6th. They then have Saturday, Sunday does not count, but then they have Monday, Tuesday, so Friday the 6th, then Monday and Tuesday the following week to be able to pay the rent, so by that day. So that would essentially be, they would have until the 11th of the month to be able to solve that pay or quit notice. Then the next type of common notice that we see is what's called a 3-day notice to cure or quit. Again, this does exclude judicial holidays and weekends, so it's 3 business days. So the 3-day notice to cure or quit is something that we will see if there's a curable lease violation. So before a landlord can issue that notice to terminate for a curable lease violation, the owner must first give the tenant the 3-day notice. This is the very first notice they receive. And this is a notice of violation, and it gives the tenant an opportunity to cure. And this, of course, is that the Tenant Protection Act applies. And the first notice usually explains how the tenant may avoid eviction. Typically, what we will see is in things like vehicles, you're not allowed to have vehicles that are broken down in front of the property. And so if a landlord gives a 3-day notice to cure or quit, it will typically say, you have 3 days to move the vehicle, or we're going to terminate this residency. So you would have 3 days to move the vehicle in order to cure that particular notice. Now, if the alleged breach is not cured within that time period set forth, they will then receive a final 3-day notice to quit without the opportunity to cure, and then they will later be served. That the property is subject to the Tenant Protection Act. Meaning, so for a cure or quit, they'll be given 3 days to be notified that they need to cure that violation. If they don't cure the violation, they'll be notified that they have 3 days before they receive their 30-day notice that they have not cured. They are not going to accept it, and then the 30-day notice will be applied from the landlord to the tenant. So I've talked a lot about the Tenant Protection Act. I went a little bit earlier. I talked very briefly about what it meant. I'm going to go a little bit more into depth about what the meaning of the Tenant Protection Act is and how it applies to individuals. So the Tenant Protection Act of 2019 is in effect till January 1st of 2030. And what it does is it provides particular protections for tenants based on their type of residency. So if a tenant resides in a unit for at least 12 months and is in a residential non-fixed term, they must be given at least a 60-day notice of termination. So if you are on a year-to-year lease, that is a fixed term tenant. But if you're on an at-will tenancy, for example, there typically isn't a time frame for that lease. So after that 12 months, the tenant has been in the residency, they must be given 60-day notice to terminate. Notwithstanding any other law, a tenant must continuously and lawfully occupy the residential property for at least 12 months. The owner of the property cannot terminate the tenancy without just cause. So there must be a reason for the individual to be kicked out. So that could be the non-payment of rent or a breach of contract. And then when they are given that termination notice, the reason for termination must be stated in writing. So in order to terminate a tenancy, a landlord must provide a reason for just cause underneath the Tenant Protection Act of 2019. If there are any additional adults that are added to the lease before the existing tenant has continuously and lawfully occupied that residence, then it turns to 24 months. And so both of these things have to be satisfied. So I know this can typically get a bit confusing. So let's just say that you've already been there for 12 months. And then you move individuals in after that 12-month period, you are subject to Tenant Protection Act based on that 12 months, but the other tenants are not. If you move individuals in, but then it also extends it, so then those tenants then become a part of 24 months. So then it extends not only the 12 months that you were there, but then 12 months after individuals that moved into your home are also there, thus meeting that 24-month period. So, and in this particular case, whenever a landlord is evicting a residence, meaning more than one or more than one individual over the age of 18, all tenants had to have continuously and lawfully occupied the property for 12 months or more. What this means is your other additional tenants must always be added to your lease. If they're not added to your lease, the landlord's only required to cover that 12 months of the according to the Tenant Protection Act. So everybody in the home must be lawfully occupied, meaning the landlord was notified in writing and they were added to the lease. Now, if more than one or more of the tenants have continuously and lawfully occupied the residential property for 24 months of all, the Tenant Protection Act of 2019 will kick in. So again, the Tenant Protection Act is all about making sure that individuals have particular protections and that they are not able to be asked to terminate their residency without a just cause. There has to be a reason why their residency is being terminated. It's not like an at-will employment. It's not just the landlord saying, no, Bob decided I don't want to rent to you anymore, you have to go. There has to be a very specific reason that the landlord is asking the tenants to move out. So what is no fault just cause? So no fault just cause can include the following: either the intent to occupy the property by the owner, their spouse, domestic partner, children, grandchildren, parents, or grandparents. So what this means is that any leases that were entered into on or after July 1 of 2020 or July 1 of 2022, if the lease is for a tenancy in a mobile home, this is a little bit differently, but what this essentially says is a just cause is if this is a private home that the property owner is renting to an individual, and they want to move back in, their spouse wants to move in, a domestic partner, their children, grandchildren, parents, grandparents, whatever it might be, that is a no fault just cause. They are the property owners and they are able, unless they have a written lease in hand, they are able to make a case for no fault just cause. Now, if the mobile home residence is this clause only applies if the tenant agrees in writing to the termination, or if the provision of the lease allows the owner to terminate the lease, or the owner or their spouse and other individuals. So mobile home residency is a little bit more tricky. We have other presentations we provided on this before, and we'll probably have one again. We do have a special program called the Mobile Home Advocacy Project. And essentially what it is mobile home residency, everybody that lives in a mobile home unit is considered, in a mobile home park, is considered a resident, but not all residents are considered owners. So there are two types of residency in mobile home parks. Either you're renting the property from the mobile home park and living in the mobile home, but you do not own it, or you're a mobile home owner. In that case, when you're a mobile home owner, it means that you own the mobile home itself and you rent the park space from park management. There are special protections for mobile home owners, different laws that apply. So some of the notices that I went over a little bit earlier do not apply to mobile home owners, but they do apply to mobile home residences that are not owners of the property. And so with mobile home owners, it works a little bit differently because unlike their term, mobile homes are not typically easy to move. And typically the expense to move a mobile home itself is more expensive than than what the actual mobile home is worth. So those particular cases, there are particular laws around mobile home residency and owners, and those types of notices are much more linked. There's a longer period in time which with a landlord must provide notification to the tenant, and there has to be certain just cause for those. So again, the information that I'm providing today does not apply to mobile home owners, but it can apply to mobile home residents that are renting the property from the space. And then another reason for a no fault just cause is the withdrawal of the property from the rental market. So again, maybe the individual has decided that they no longer want to rent the property. They want to move somebody into it. Maybe they want to sell the property, whatever that reason might be. That is what's called a no fault just cause, and property owners are legally able to do this as long as there's no fixed lease attached to that particular residency. So, but if they are outside that lease term, so let's say that the initial lease is a 12-month lease and they're agreeing that this individual can live in their home for 12 months, they can't break that 12 months. They can't break that lease within that 12 months unless there's just cause to do so. Once that lease has expired, the property owner has complete authorization to make those decisions, and that's called a no fault just cause case. Another reason for no fault just cause is that the owner is complying with any of the following situations. They might have been given an order issued by a government agency or court relating to habitability that requires the vacating of the residential property. So if there are habitability issues and they have been notified that the property that they own is not habitable for residency and that they are required to vacate the premises and make repairs, that is what's called a no fault just cause. They might also have been ordered by the agency to vacate the property for other reasons that do not apply to habitability issues, but it is issued by a particular government agency or court. Or they might have a local ordinance that requires the vacating of the residential real property. So if at any time it's determined by a government agency or court that the tenant is at fault for the condition or conditions triggering the order or need to vacate underneath this clause, the tenant is not entitled to relocation assistance. So what that means is if a habitability issue is occurring on a property and it is the landlord's fault, they must provide relocation assistance. If the tenant is the reason why the habitability issue is in fault, then the tenant is no longer entitled, the landlord's no longer required to provide relocation assistance to their tenant. The next reason would be the intent to demolish or substantially remodel a residential real property. So substantially remodel means the replacement or substantial modification of a structural, electrical, plumbing, or mechanical system that requires a permit from a governmental agency, or the abatement of hazardous materials, including lead-based paint, mold, or asbestos, in accordance with applicable federal, state, and local laws that cannot be reasonably accomplished in a safe manner with the tenant in place and requires the tenant to vacate the property for at least 30 days. So what this means is if it's something that is going, again, it comes to a habitability issue. So if it's something that has to do with, it will cause harm to the individuals that they're in the home while this work is being done, then they have to leave for at least 30 days. This could be a no fault just cause. Now, cosmetic improvements alone do not qualify for just cause. So if the landlord wants to come in and let's say they want to repaint the whole entire house, they cannot ask a tenant to leave a residence if they want to repaint. If they're decorating, creating minor repairs, let's say there's some cracks in the stucco on the outside of the building, they cannot ask an individual to vacate the premise to make stucco repairs. And then any other work that can be performed safely without having the property vacated does not qualify as a substantial rehabilitation. So again, if the intent is to demolish or substantially remodel the property, a landlord can ask a tenant to leave and can break a lease because they've been ordered to by a particular agency because of permit reasons. So now we're going to go into what the actual eviction process is. So an eviction process, that's what it's commonly known, is what the legal term for that is unlawful detainer. So an unlawful detainer is filed with the courts after the expiration of a termination notice, as it becomes basis for an eviction action in court. So after that unlawful detainer complaint is filed, the tenant must be served before an obligation to respond exists. So a tenant will never be evicted from the property and not be aware of that. The landlord has to notify them first with the pre-eviction notice. So maybe it's a 3-day pay or quit. They do not pay their rent within those 3 days, so then they receive a 30-day notice. Once that 30-day notice is expired, the landlord can then file the unlawful detainer, also known as the eviction, and then the tenant has to be notified the eviction has been done. So generally, tenants will have 5 days after the service is complete to respond to the complaint. So again, this excludes judicial holidays and weekends. If they receive a notice on Friday of the week, they have until the following Thursday to reply. So now there have been times and there have been situations where individuals have received illegal unlawful detainers, meaning the thorough process was not done by the landlord. This does happen. It's not very common, but it has happened. We have seen cases of this and going on. So if you or someone that you know receives a summons or a complaint regarding an unlawful detainer, we highly encourage the individual to contact GBLA immediately. Now, we do not help individuals you must be, in order to qualify for services and to get assistance with the eviction process, you must be low income. So we only accept the cases for low income individuals, but we highly encourage individuals to contact us immediately so that we can begin that process and help with their case. If it is found that we have a case and it's found that the unlawful detainer was given by the tenant, given by the landlord to the tenant illegally, we will fight for that individual. So in order for the landlord to obtain the possession of the property, they must first obtain the judgment for possession in court, meaning they file the unlawful detainer case, they notify the tenant of the eviction process, and then the court awards the landlord the ability to evict the process. Once that's done, then they can enforce the judgment with what's called a writ of possession. And that writ of possession gives them the authority to have a levying officer, which is usually a sheriff, serve that writ of possession. And what that writ of possession says is that the tenant has been ordered by the courts to vacate the premises. And so then the writ of possession will be served to the tenants by a levying officer, and all occupants will be notified that a forcible lockout will occur. This is also what's called a notice to vacate. So unlike your pre-eviction notices where there were opportunities to fix this, once the unlawful detainer actually happens and the court has approved them, they will be given a notice to vacate, and they will have 5 days to move out before they're locked out and they're unable to get back into the property. This is why it is so very important for individuals to contact us as soon as possible. So even if the unlawful detainer is legal and legit and the court has approved it, we will help individuals potentially negotiate with landlords. So 5 days is a very short window of time for individuals to get all of their property out of a particular residence. And so we will actually help individuals with that negotiation, and sometimes, not always, but sometimes the landlords will work with individuals and give a period of time, an extended period of time before they're actually locked out of the property. So this is an example of what the writ of possession looks like. So if the plaintiff obtains this judgment, which is typically the landlord, the plaintiff will be able to enforce the judgment through writ of possession procedures unless the defendant voluntarily vacates the subject property. A prevailing plaintiff is entitled upon request to immediate issuance of the writ of possession, and once the writ is issued, it must be served by a levying officer such as a law enforcement agent like the sheriff. The service must be personal and substitute or by post or mail, and is enforceable for a 180-day period from the issuance date. So if the writ expires, the plaintiff must obtain a new writ of possession. So once the landlord receives the once the court orders that the unlawful detainer is legal and the landlord has the ability to offer this writ of possession, there have been times where situations where individuals didn't necessarily serve within those 5 days. But once the tenant has been given that notice, it is a 5-day before lockout. But the landlord has 180 days to provide that to the tenant. So this is what an unlawful detainer looks like. It's a little bit different than your notices. So any notices that the tenant receives from the landlord will typically not have court information on it. Those are your pre-eviction notices. Once the unlawful detainer notice, the eviction is actually filed and approved by the courts, this is the actual documentation. So they will receive an actual court-ordered judgment that looks like this. So there is the summons himself, which gives you information about what it is and what you'll find inside, and then they'll have additional information located on this page here. If a tenant receives this information, this is again important, they call us as soon as possible so we can help negotiate and the ability for them to remove their property from the home. Just some more information about this. It's a very short letter. It's not very long. It's not a thick stack of papers. It's very clear, concise, and to the point. Again, this is what's called the unlawful detainer, which is the actual eviction process. A notice from a landlord that is not court ordered is not an eviction. So the only time that an individual is being evicted, they will receive these actual court papers. So a little bit of misconceptions about this is that at the expiration of the notice, you can stay at the residence or move out. This is important for individuals to understand that if they choose to stay past the expiration of a notice, they are subject to the unlawful detainer process. So if they are given a 3-day pay or quit and they do not pay the rent, they'll be given a 30-day notice to move out. And once that 30-day notice is up, if they are not moved out, they will then become subject to the eviction process. After expiration of the notice, a landlord cannot simply show up with law enforcement to remove a tenant. The only time that a landlord can force a tenant out is if they have filed the proper paperwork for an unlawful detainer, they have received the court judgment, and then it'll be the sheriff or another levying officer to notify. But law enforcement will not show up to remove a tenant without that writ of possession. The landlord can also not cancel your electricity or water service in order to constructively evict you. A lot of individuals become fearful that if they don't leave the property, the landlord is able to shut off their power. That is not true. They are not able to cancel power to the home. They also cannot change locks or lock an entry gate to constructively evict you. So again, a landlord, in order to legally and lawfully remove a residence from a property, they have to have filed the proper paperwork and went through the proper eviction process, known as the unlawful detainer. Now, of course, if you ever feel that you're being harassed by your landlord or feel that you're in imminent danger, we encourage you to call law enforcement right away. Unfortunately, there have been some cases where it has gotten pretty messy between landlords and tenants, and there have been times that individuals have felt unsafe because the landlord, for one reason or another. So please make sure you call law enforcement immediately, and if you're going through the process, please call GBLA. Now, some more information regarding tenant rights. You have the right to translated documents if you negotiate the lease in the specified language that it was done. So if you speak a language other than, and just for example, let's just say that you speak a language other than English, the property owner has all the information in English. You lawfully, as a tenant, have the right to request that information in the language that you speak. And if you have the lease translated to a specific language, all communication from the landlord must also be in that language. So we're just for an example, I will use Spanish-speaking residents. If the lease was translated into Spanish for the Spanish-speaking resident to be able to read and understand that document, every notification that that resident should receive the landlord therein and forward should always also be in Spanish. It's very important that landlords follow that policy because you don't want to give any kind of misconception. Now, some other harassment, and again, we have a whole other unit called our Fair Housing Law Project that goes more into depth about this. We have a whole other presentation that goes more into discrimination, but residents have tenant rights. And those rights include they are not to be discriminated based on race, color, religion, sex, their gender identity, their gender expression, sexual orientation, marital status, national origin, ancestry, familiar status, source of income, including housing vouchers and other assistance program income, disability, citizenship, immigration status, their language, military, or veteran status, their age, genetic information, or arbitrary characteristics. And arbitrary characteristics are your physical traits. So again, if you feel that you are being discriminated against, please give us a call as soon as possible. We have a whole other unit that handles discrimination cases. Now, typically we will see individuals. We will typically work together. So we will, if we receive a case that is going through the eviction process and it is found that there might have been some discrimination that occurred, well, typically those two units will then team together. The Fair Housing Law Project and the housing unit will team together for a resolution that's best for the tenant. So I went ahead and also listed some additional resources available. These are typically referral services that we will make to individuals with our Housing Navigators. So of course, we always have our Kern County Bar Association that has information about who we are and what we have the legal authority to do, in addition to other attorneys in town. So if we are unable to serve you based on eligibility, you can always contact the Bar Association to find a referral service for another attorney in the area. Our aging and adult services, we typically will make referrals whenever we find reasons for abuse or neglect for our older individuals. And then one thing that I want to mention, I should have mentioned a little bit earlier, apologies for that. In order to apply for the rental assistance program through the Housing Authority, you have to go to kernha.org. That's the assistance portal website. 211 is the county assistance line that is operated through CAP-K. That is the system that we send all individuals to that are at risk of homelessness or already homeless. And so services provided outside of our agency, individuals must go through that particular number. Code compliance, there is county and city code compliance, so both of those are listed here. So anytime you feel as a resident, or if you have clients that have residents, if you have clients that are having issues with code compliance or habitability, it's highly recommended that a formal complaints be made with both of these agencies. And then of course we have some other information for homeless individuals. The COVID declaration information can be found at housing.ca.gov. That the COVID declaration has to be filled out, or if you are reporting to your landlord that you're unable to pay rent due to COVID-related financial hardship. Then of course there's other, in addition to the rental assistance program through the Housing Authority and CAP-K's rental and utility assistance program, there's also another program called Housing is Key. And then there's also, I talked a lot about the Housing Authority Rental Assistance Program, but please do be aware that CAP-K also has a rental and utility assistance program as well. In addition to that, they also have what's called their HEAP, which is the Home Energy Assistance Program, where they help individuals get their home to a certain level to make sure that they are efficient, so that get a little confused there. Sorry, the program is all about making sure individuals can receive services to ensure that they are receiving the most efficient utility service. And this is all in the goal of making sure that they're not paying an astronomical price for their utility bill. So if there's, cracks in the windows, or they have a really old fridge that just burns power and causes their electricity bill to go really high, CAP-K has a program where they can actually help replace some of those or fix some of those situations so that individuals can lower their utility bills. So that is the end of our presentation today. So you were muted during the presentation, but I can go ahead and take any questions at this time. You can either use the question box or raise your hand, and I'll give just a moment for that. And I do have a question here. Let me just get to it. It says, while tenants await response from Housing Authority about the rental assistance, can a landlord move forward with the eviction process? No. So that was part of the moratorium that was put into place. If an individual was unable to make their rent due to financial hardship, the moratorium was put into place, and what it states is, and even though the moratorium's expired, the policy is still in place. The tenant or the landlord, either or, can actually apply for that rental assistance program. And if the tenant applies, they must notify the landlord, and then the landlord cannot evict the tenant or move forward with the eviction process if there's an application pending, because if that application is processed and approved, that tenant's rent will now be paid. And then vice versa. If the landlord applies for the assistance program, they must notify the tenant so the tenant is aware so they can um, um, make the proper adjustments to make sure that the rent is paid. So if a rental assistance application is still currently in process while they're waiting for that approval, you can't, and landlord is not able to move forward with the eviction process. So I'm going to just do one more scan through, make sure we don't have any other questions at this time. So I don't see any other questions at this time, and I don't see any hands raised. Oh, there's one that came up. Is there anything a tenant can do if he or she was evicted because the landlord did not respect this moratorium and the rental assistance application was received after they were evicted? Yes, call us immediately. That is definitely case. Those are definitely cases we will take on a high priority. There were certain laws in place, and the laws and the policies were in place to protect tenants to prevent this unlawful eviction process. So absolutely, if they have already been evicted because the landlord, and if the landlord did not follow those policies and evicted the tenant, we absolutely request they call us immediately. Now I can't make any promises or guarantees, but typically that would lead to what we call litigation, which we would then go on behalf of the tenant and sue the landlord because of that lack. And the current time around for GBLA return a phone call. So once, this is another misconception that I've been trying to share with the community, we don't have an answering service. The only time that we accept intake calls is from 8:30 to 12 and 1 to 4:30 Monday through Friday. So the best advice I give is call and call and call until you finally reach somebody. Now, once an individual has actually reached an intake coordinator at GBLA, they'll take some basic information, client information like contact, and then the reason for the case and so forth. And then typically it's about a 48-hour turnaround that the case is then assigned to an individual and turned around. Now, we have been overwhelmed with some of these evictions, and so it has taken us sometimes a little bit longer, but depending on what type of notice. So if it's an unlawful detainer, we respond to those a lot more quickly than we do if an individual is calling because they need assistance on how to cure their current notice that they received. So typically it's 48 hours, but all we can say is to call. Our lines do get very busy. Our busiest time of day is from 8:30 until about 11. And then in the afternoon, we're typically busiest from about 3 to 4:30. But again, they need to continuously call until they get a hold of somebody. We do not have an answering service. I'm going to do another scan through, make sure we don't have any other questions at this time. Okay, so with that, I don't have any other questions. And now my contact information was provided in the registration and will also come out in a notice after this webinar concludes. Now this was recorded today. We will apply this to our, add this to our YouTube channel and disseminate through our social media channels at a later date. We have also been doing Third Thursday since January of this year. So we have also featured, there's been other housing presentations as well as fair housing and other programs and other units here at GBLA. Those are also located on our YouTube channel to watch at any time. We've also launched Second Saturday, our first being in July and our last happening last week. So we now have Third Thursday every every month with GBLA and Second Saturday. Each month will feature a different unit. The reason why we chose to do housing unit again this month is because of the relevance of the rental assistance application program and making sure we got the word out that we not only help with individuals apply, but that denial process is really key for individuals right now. So we want people to know if they get that denial notice, not only do they need to contact their caseworker at Housing Authority immediately, but they can reach out to GBLA for help. But thank you so much for joining me on a Thursday afternoon. With that, I'm going to go ahead and wrap up Third Thursday with GBLA, and I hope to see you all next month. Thank you for attending.